Very good evening, Rohit. Very good evening, Kunal, and everyone, those of you who have just joined. Good evening, everyone. I hope you all are doing fine. So, first of all, I welcome each one of you to my class on the Code of Criminal Procedure 1973. Let's start with my brief introduction. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen. And this is the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask your questions. At last, I have shared my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. So the moment you feel you are not clear with anything, feel free to ask your questions in the comments. So students, before starting this class in which we are going to discuss the concept of proclaimed offender, if you do have any questions in your mind in relation to CrPC, you may ask. Any questions, problems? Yes, Rohit, Kunal, or anyone, if you do have any questions in relation to CrPC, you may ask. Okay. So let's begin with this topic, that is proclaimed offender. First, let's get into the basic introduction. Uh, if summons has been sent or if warrants has been issued and still the court believes that the person against whom the summons or the warrant has been issued, or especially when it comes to the cases of warrant, if the court has reason to believe that the person is not going to present himself in the court of law, then there comes the option of proclamation. In this, we are going to discuss in detail the concept of section number 82. So let's start with the section 82. Proclamation for person absconding. Clause 1. If any court has reason to believe, this is again important, if the court, so who can give proclamation? The answer is only court can give proclamation. The second point, when can court give proclamation? The very first point, when the court has reason to believe. This term reason to believe has been defined under section 26 of IPC. Whether after taking evidence or not that any person against whom a warrant has been issued by, so which means the second important essential for section number 82 is, one is reason to believe and warrant has been issued. So that is your prima facie, the very first essential which needs to be fulfilled. Warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed. Such court may publish, may, which means it is the discretion of the court that whether the court wants to proclaim it or not. Against whom warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place. So now coming to what is the objective? What is the objective of proclamation? That is the appearance only. Appearance in the court of law. Such court may publish a written proclamation requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publishing such proclamation, which means as per to the proclamation you need minimum time period of 30 days, minimum time period of 30 days, not 29, minimum 30 days, so that he can prepare himself for that appearance. So this is your clause 1. Clause 2 says the proclamation shall be published as follows. So how the proclamation is going to be published? It shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. So, in every place, in like, suppose if the person is living in a society, so even a society has a one common area where usually people gather. So, at that particular place, that proclamation may be read. It shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides. So, suppose this is the house, this is the main gate of the house, and that needs to be published. That needs to be pasted on that entrance gate. A copy thereof shall be affixed to some conspicuous part of the courthouse. So that will be also pasted in the court. Which court? That court which has issued that proclamation. The court may also, if it thinks fit, direct a copy of the proclamation to be in a daily newspaper. Now, the exam is, it is mandatory to be published in the newspaper, or is it the discretion of the court? So the answer lies in, it is always the discretion of the court. The court may also, if it thinks fit, direct a copy. So the word may has been used. So maybe, maybe not. A copy of the proclamation to be published in a daily newspaper circulating in the place in which such person ordinarily resides. I hope everyone is clear with these two clauses. Good evening, Shivangi. Okay. Now, continuing with this, you must have noticed this point that section 82, clause 4 only used the term proclaimed offender. When you read section 82 clause, it is not that the word proclaimed offender has been used. So, who is proclaimed offender? So, for that, let's go through with section number 82, clause 4. Where a proclamation published under subsection 1 is in respect of a person accused of an offense punishable under. So, which means there is a list of offenses. Okay, there is a list of punishment sections, basically the two with. If your case falls under any of these offenses, then only that person may be called as proclaimed offender. And such person fails to proclamation after giving him 30 days, known as a proclaimed offender as per to section 82 clause 4. And such person fails to appear at a specified place and time required by the proclamation, the court may, after making such inquiry as things fit, pronounce him a proclaimed offender and make a declaration to that effect. Shivani, which process you are talking about? Munadi process. This term has not been used in CrPC. Okay, this Munadi process. Okay, continuing with that. Now, coming to what is the purpose of this proclamation? Now, I'm going to conclude this whole concept of section 82. If summons are not working, the warrant is not working, then we may go with the option of proclamation. And if even after the proclamation the person is not representing himself, the overall objective was to make his appearance in the court of law. But if the person is still not coming to the court, then the court may go into the options of section number 83, read with section number 84 and section number 85. Now what are these sections? Under section 83, then the court has the power to attach his property, either the movable property or the immovable property. Okay, And usually students ask, sir, what if he don't have any property? If he does not own any property, movable or immovable, then obviously you cannot exercise the option under section 83. So 83 is basically attachment of property. Now coming to the concept of section 84. If any person is raising a claim that the property that has been attached is not of the accused, or in relation to attachment, so if anyone wants to make any objection in relation to the attachment, then the process is under section 84. You will give 6 months after the attachment. So within 6 months, you can approach the court and you can raise your objection in relation to the attachment of the property. Still, if you are the aggrieved party about the decision of the court, then you will get 1 year of period of limitation, and you may lodge the proper suit as well as per to CPC in relation to that property. So this is your something which where you can claim an objection. Now coming to the last section, that is section number 85, which basically talks about of three concepts. The first one is the release of the property, the second one is of the sale of the property, and the third one is restoration. The very first one, release, when the court will release the property. The moment the person appear himself in the court of the law, then the court will release that property as per to section 85. Now coming to the second concept, sale. If the person is still not coming after attachment, then the court may go for the option of sale, but court must wait for at least 6 months. And the last one, if after the sale, but before the lapse of 2 years, if the person represent himself in the court of law, then the court will give him the money after all the relevant deductions, that the expenses in which has occurred during the attachment or during the sale, that must be deducted, and rest amount will be restored to that person. So these three concepts, release, sale, and restorations, dealt with section number 85. Now if you have any questions from section number 82, 83, 84, or 85, yes please. Okay, Deepji, you have asked one question. What is the difference between person and proclaimed offender? Proclaimed offender is under your section 84, 82 in the court of law. If all these three essentials have been fulfilled, 1, 2, and 3, then that person will be known as, and this is your as per to section 82 clause 4. These are just two examples. The list is 302, 304, basically your culpable homicide or murder, 364, 367, all these are sections from the IPC. Done? Okay, now coming to proclaimed person. Who is a proclaimed? Section 82, clause 2, subclause 1A. This basically deals with Munadi process. वीडियो स्टक हो रहा है. Students, please confirm about the video. Is it working fine now? ओके, परफेक्ट। दीप, मैं पहले शिवांगी का क्वेश्चन आंसर कर रहा हूं, उसके बाद आपके लिए मैं रिपीट कर दूंगा कि व्हाट इज द डिफरेंस बिटवीन प्रोक्लेम्ड ऑफेंडर एंड प्रोक्लेम्ड पर्सन। ओके, मैं दोनों के आंसर्स को रिपीट कर रहा हूं। फाइन। फर्स्ट आंसर, शिवांगी आपने पूछा था मुनादी प्रोसेस क्या होता है, तो पहले तो मैं ये बता दूं कि पूरे सीआरपीसी में इस टर्म को यूज नहीं किया गया है। मुनादी प्रोसेस इज लाइक, आपने वो सुना होगा ना, गली में आते हैं ढोल लेके, सुनो 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 सुनो, एंड देन दे मेड एन अनाउंसमेंट। तो यूजुअली आप पहले जमाने में जब आप देखते, तो पहले जमाने में इन शॉर्ट कि थोड़ा पहले जाएंगे आप 20 से 30 साल पहले, तो यूजुअली ये प्रोसेस ज्यादा होता था। तो मुनादी प्रोसेस अगर आपको इस क्लॉज में देखना है तो वो आपको मिलेगा सेक्शन 82 क्लॉज 2 सब क्लॉज 1A में, जो इट शैल बी पब्लिकली रीड इन सम कॉन्स्पिकुअस प्लेस ऑफ द टाउन और विलेज इन विच सच पर्सन ऑर्डिनरीली रिजाइड्स। उसी को बेसिकली यहां पर आप मुनादी प्रोसेस से रिलेट कर सकते हैं। आई होप कि ये क्लियर है। शिवांगी, आर यू डन विद योर आंसर? क्लियर? ओके, नाउ दीप, आई एम मूविंग टू योर आंसर। सुनिएगा ध्यान से। दीप, दो कॉन्सेप्ट्स हैं, वन इज प्रोक्लेम्ड ऑफेंडर, वन इज प्रोक्लेम्ड पर्सन। पहले समझिए हु इज प्रोक्लेम्ड ऑफेंडर। अगर कोर्ट ने प्रोक्लेमेशन की है 82 क्लॉज 1 में, विच मीन्स कि 30 डेज दिए हैं किसी को प्रेजेंट होने के लिए, ठीक है जी, और वो जो ऑफेंस उसने किया है जिसके लिए वो एक्यूज किया गया है, वो आपका इस लिस्ट में फॉल करता है, जो पूरी की पूरी लिस्ट आपको सेक्शन 82 क्लॉज 4 में दी गई है, जिसमें से मैंने कुछ एग्जांपल्स लिए हैं 302 या 304 में। और वो पर्सन फिर कोर्ट के सामने नहीं आता है, फेल्स टू अपीयर इन द कोर्ट ऑफ लॉ, तो उसे हम क्या कहेंगे? प्रोक्लेम्ड ऑफेंडर कहेंगे। सो दिस इज योर वन कॉन्सेप्ट। नाउ कमिंग टू हु इज प्रोक्लेम्ड पर्सन। अगर एक कोर्ट ने प्रोक्लेमेशन पेस्ट की है अंडर सेक्शन 82 क्लॉज 1, और वो जो एक्यूज है जिस ऑफेंस के लिए, वो इस लिस्ट में फॉल नहीं करता है, इस लिस्ट में, जो कौन सी लिस्ट में, जो सेक्शन 82 क्लॉज 4 में आपकी लिस्ट दी गई है, उस लिस्ट में फॉल नहीं करता है, एंड देन ही फेल्स टू अपीयर इन द कोर्ट ऑफ लॉ, तो उसे हम कहेंगे प्रोक्लेम्ड पर्सन। आई होप दीप इट इज क्लियर नाउ, द डिफरेंस बिटवीन प्रोक्लेम्ड ऑफेंडर एंड प्रोक्लेम्ड पर्सन। आज थोड़ा इंटरनेट इशू है, सॉरी अबाउट दैट। आई थिंक अभी भी शायद बार बार वीडियो स्ट्रक हो रहा है। शिवांगी गॉट हर आंसर। दीप, आर यू देयर? चलिए, एनीवन एल्स, एनी अदर क्वेश्चंस? चलिए जी, so let's conclude the class. So students, this is the link of my profile of Unacademy, this is the link of my Telegram channel, and this is my code Khatri10. Let's crack PCSJ with Unacademy. You can get flat 20% off on judiciary subscription, and this offer is from Feb 16 to 21. There's a free all India judiciary scholarship test, so make sure you enroll yourself as soon as possible. The test is on 5th of March at 12 p.m. Indian Standard Time. Unacademy is launching Safalta 4.0 comprehensive batch, already started from Feb 16th. Then one is your linking batch for Rajasthan Judicial Services and Gujarat Judicial Services. The start already started from Feb 18th. Launching revision batch for UP mains exam, and this is going to start from Feb 23. Chhattisgarh Judiciary Prelims mock test series, and similar on Punjab Judiciary as well. and UP Judiciary as well. If you are preparing for UP mains, Punjab mains, or Chhattisgarh prelims, you can go with that. शिवांगी सेक्शन मैंने लिखा तो है यहाँ पे. दिस इज द सेक्शन. ये रहा आपका सेक्शन नंबर 82 क्लॉज 2 का सब क्लॉज 1. डन शिवांगी. सेक्शन नंबर लीगल एडवाइजर, लीगल लॉ. फीस कितनी है? फॉर फीस यू कैन विजिट you can see the fee structure as well in this slide. For UP Judiciary, it is 2,999. 2,999. For Punjab Judiciary, it is 4,999. For Chhattisgarh Judiciary, it is 500 only. Okay, so that's the fee structure. You can see the price as well in all these slides. Anything else, students? Good evening, Savitri.